human rights provisions. Here you have Article 5 of the European Convention on Human Rights. Everyone has the right to liberty, security of person. No one shall be deprived of his liberty save in the following cases, and that includes the lawful detention of a person after conviction by a competent court. So you can't say that prison in some fundamental way violates modern human rights law. In fact, for reasons I'm going to suggest in a moment, the prison is a child of the birth of human rights law in the 18th century, and that prison you see there, which is a Dutch prison at Scheveningen in The Hague, has been given to the United Nations to use as their detention center for people who have been indicted by or convicted by the International Criminal Court. That's also where people were held during the Criminal Tribunal for the former Yugoslavia, as well as the Rwanda case. This, although it's not obviously limited to Europeans, in fact, I think all the prisoners here are currently African, which raises some interesting post-colonial issues about the modern human rights regime. But in any event, this is about as European a prison as you could have, in the sense that the European community does embrace modern human rights, including the International Criminal Court, and they have a classic prison that doesn't look all that different if you look at the outside of Folsom Prison, has a similar gate to this. In the United States, well, let me step back. Historically, the prison as we know it today was very much an outgrowth of what I would argue, and maybe Professor LaCour will correct me, is at least one of the first moments where there's a kind of European-wide consciousness of human rights as a problem, and that is the end of the 18th century when a man named John Howard, for the English-speaking world, he has his equivalents in France and Italy, and he himself is visiting European jails. He writes a book called The State of the Jails, and what he exposes is sort of the terrible, terrible conditions that you find all over Europe at the end of the 18th century in workhouses, in asylums, and in jails. And these are places of great disease and suffering. People are thrown together. This is actually a powerful illustration, a work of art created by an 18th century artist, Romney. But all over Europe, there were paintings of similar scenes of lazarettos or jails being flung open, and this is very much the light of human rights and a kind of Enlightenment thought coming in. That's John Howard exposing these terrible conditions. And Howard then designed one of the kind of model penitentiaries that was built in the 19th century. That's a prison that was built at his design. And you can see that I don't know how many of you have visited, a classic American prisons like San Quentin, but this is still, other than the sort of newfangled prisons like Pelican Bay or Guantanamo, this was from the 19th and into the 20th century, sort of your model prison designed to keep people separated, the people who were in that swarm, to give them lots of fresh air and nutritious sunlight. This was supposed to be an enlightened human rights way to deal with serious crime, instead of executing people on the scaffold, torturing them or mutilating their bodies in various kinds of corporal punishments, or ignoring crime, which was a frequent 18th century approach to serious crime. Just ignore it or hope that it goes away and bothers somebody else. So I guess the point here is that the prison, far from being an outcast of human rights law, is a product of it in certain ways. And in the United States, we had our own sort of human rights although it wasn't called that, but a kind of human rights experiment with prisons in the 1970s when our federal courts, using the Eighth Amendment, the language of which I had up in a previous slide, but which, as you know, forbids cruel and unusual punishment, in a series of decisions, one of the most famous being Ruiz versus Estelle, which was a sweeping condemnation of the Texas prison system in the early 1970s. These federal court decisions began to impose a kind of human rights-based set of conditions on prisons. You have to have humane conditions physically. You have to provide adequate health care, something that we're going to come back to in a big way in a moment. You have to create conditions for both living and working environments that will be conducive to the modern prison. Now, interestingly, I think both the prison in Europe and the prison in the 1970s in the US could be embraced by a kind of human rights-oriented legality, because it was a prison that promised, at least in its aspirations, that its goal was to rehabilitate people, to protect them against the vengeful anger of the public, to keep them in essentially in a dignified and safe, if retributive, if unpleasant circumstance. And indeed, a lot of these decisions, like Ruiz, as my colleague Malcolm Feely in his very good book with Ed Rubin on this period of judicial prison reform, showed that these courts basically took note of the fact that rehabilitation was in the 70s the dominant penal ideology across the country, as well as the rest of the world, and said, well, if rehabilitation is your goal, then we can actually use the Eighth Amendment to require you to live up to that promise, or at least not have conditions that are fundamentally incompatible with that. Now, that was true up until the 1970s. In a sense, what I want to argue is that up till the 1970s, both America and Europe, as just two global societies and modern societies, had both modern penal systems that included the death penalty and imprisonment, and a fairly robust legal commitment to human rights, although in America we talked about it totally in constitutional terms, but they were very much on the same wavelength. Now, that kind of period of relative parallelism changed after the 1970s, that period of mass incarceration that I showed you in the graph at the beginning. And essentially, what has emerged is what I want to call, following legal historian James Whitman, a dignity difference. That there has emerged a real difference between Europe and the United States, and it's fundamentally to do with it may fundamentally be to do with our inability culturally and historically to have really come to terms with dignity, which is, as you may know, a foundational concept in modern human rights law. So basically, if you look at the United States and Europe since the 70s, we have diverged. In the United States, after an initial challenge to the death penalty, we reinstated the death penalty as a legal penalty in 1976, and at least for the next 20 years, we got more and more use. We used it more and more frequently, sent more people to prison. Here in California, you may know, we have almost 1,000 people on death row, although we execute people very rarely for reasons that I could explain to you. Our incarceration rate expanded by more than fourfold between 1975 and 2005. Now, in Europe, even though they accepted the death penalty in the 70s, they banned it by the 80s, and this was after most of the nations had independently abolished it. Incarceration, it's very hard to characterize Europe as a single entity for penal purposes, just as obviously it is for monetary purposes. But unlike monetary purposes, they don't have one incarceration rate for Europe. So I'm kind of faking this by saying that in this period, but that's about right. Some countries like the Netherlands have grown almost as fast as the United States in a slightly different time period. But I think overall, the European average would be about a doubling, which tells you two things. One, Europe has a lot of the same pressures to expand prisons that we have, public fear of crime, state problems of legitimacy, etc. But they've also had a pushback that has prevented this blowing out of incarceration. They also don't have a bunch of things we have. Life without parole sentences. By the way, last time I was here, I was talking about Graham versus Florida, a case that had held that juveniles sentenced to life without parole for a non-homicide crime, that was unconstitutional, disproportionate punishment, which is a very much of a human rights idea that is sometimes enforced under the Eighth Amendment. Well, that I said at the time, that case is a kind of a question mark, because very few juveniles around the country are in that position. There was about 200. There's about 4,000 people who were sentenced to life without parole as juveniles. They're no longer juveniles typically because they've aged, but for homicide crimes. And just yesterday, the Supreme Court announced that they're going to consider that case. That was in today's newspaper. So this is, history is unfolding here. But for the moment, we have life without parole. We have supermax prisons like Pelican Bay. And as you know, and as our friend from the International Monetary Fund found out, we have very harsh consequences when you're even charged with a crime in America. You can be hauled in front of cameras and handcuffed in very embarrassing ways, as Dominique Strauss-Kahn was. And when you get out of prison, you can have your information is publicized on databases as a criminal. You can't get a job. You can't get credit. That's all standard in America. In Europe, that would be illegal under human rights norms. Europe doesn't have LWOP and probably wouldn't permit it under human rights norms. It doesn't have supermax prisons and probably wouldn't permit it. So clearly we've had a big divergence. Now the question is, one quick question is why? And I'm already behind, so I'm not going to spend too much time on this. James Whitman, the historian I mentioned, writes this very interesting book, which I recommend to you, arguing that America is different from Europe, not just quantitatively, but in some of the qualitative ways I've been showing you, primarily because they went through a cultural evolution that gave them a strong commitment to dignity, and we didn't. And I can give you a very quick version of that. It comes down to two historical differences. One is, in a sense, in America, democracy came too soon. We got essentially universal white male suffrage at the birth of the Republic. We kicked out the aristocracy. You could not be, George Washington in another country would have been a duke or a count, but he wasn't. You can have no titles of nobility under our Constitution. I've in fact wondered whether being called the Adrian A. Craigen Professor of Law at a public university, violates that norm on some level. But in any event, we have no aristocracy, right? That's one of our contradictions, right? The Koch brothers are not an aristocracy. They may act like one, they may feel like one, but they don't feel like one to us because we don't believe in aristocrats. Now, normally we celebrate that. Why would we be sorry about it now? Well, what Whitman points out is that over a 300-year period, the European nation state, as it became a modern nation state, had to digest the aristocracy and basically turn them into normal citizens. And in doing so, it basically upgraded the meaning of citizenship to the aristocratic level, right? So in a European prison, the guards call the prisoners Herr or Monsieur. They don't call them Joe or prisoner X543 or, Nigger, God forbid, right? They call them Monsieur or Herr. There's a normalization of everybody up to essentially an aristocratic level. Now that's a broad cultural difference, but it had a lot of importance for the penal field. For many centuries, aristocrats got different punishments in Europe. So there was a different mode of executing aristocrats. You may not know that. On the continent, that meant you got a clean beheading rather than strangulation, burning, or a more painful death or degrading death. That was considered more dignified. Now, it may not mean a lot to you and me, but it was important to those aristocrats, or at least they claimed it was. Later, when prison became the more important punishment, aristocrats got special treatment. They were put in what were called fortress prisons, where they were essentially allowed to live a dignified life with their servants and their relatives and friends visiting, but just isolated to some degree. And over the years, what Whitman shows is that Europeans pushed the category of prisoners deserving aristocratic treatment further and further out. So if you were a political prisoner, you were considered to deserve aristocratic treatment. That's why Hitler, after the beer hall push, was kept in essentially an aristocratic prison where he was visited by journalists, had his own cook, wrote Mein Kampf and things of this nature. At any rate, we didn't get that because we didn't go through this long process of digesting the aristocracy. So if democracy came too soon, our other problem is that slavery left too late. We had one form of status differentiation, let's put gender aside for the moment, that was between black and white people. That was even more degrading, right, than aristocracy, which was a sort of a series of hierarchical honors. We considered sort of white males to be just plain folks, and then from there down, it was degradation. Doesn't like my sweater. Okay. So again, notice these illustrations. This difference about slavery worked itself profoundly into our penal system because it was very much expressed as a penal enterprise. The plantation was essentially a form of punishment and a form of state punishment. So democracy came too soon, slavery left too late. Let me flash forward from 200 years of history to American penal populism in the 1990s. That has given us this massively expanded prison system, held out to the public as a form of identity with ordinary victims, crime victims. It's a deeply racialized prison population with typical prison system would be about 3/4 black and brown, California a bit more. And so it's overwhelmingly a majority institution, prisons. And they are viewed as essentially a form of populist